public policy. People want tough sentences like the three strikes law. This law is, again, something that somebody may want to write a paper on. The Prison Litigation Reform Act of 1996 is an example that you could only get in America, and I think expresses the real difference with Europe. This is what you could call an anti-human rights law. It's basically a law designed to prevent courts from enforcing constitutional rights in state prisons. It was signed by Bill Clinton, to his everlasting shame, I believe. And it makes it very, very hard for a federal judge to order prison reform. It's an attempt to prevent all that kind of human rights reform that happened in the 70s. And one of the things it does is it forces judges who want to reduce prison populations, the way that just happened in California, to explicitly consider whether that will increase the risk to public safety. It also allows sheriffs and police departments and prosecutors to intervene with all kinds of rights to stop up the legal process. Governing through crime, right? That's my earlier book, and I just mean here that the very interveners that this law permits, sheriffs, police chiefs, prosecutors, are the kind of leaders that in a world of governing through crime have the most strong commitment to sort of promoting fear of crime, political anger about crime, and willingness to punish very toughly. So let me, with all that as a rather overly long background, let me quickly tell you about what this case did. So before you had Brown versus Plata, the earliest version of that case was called Coleman versus Wilson, Pete Wilson, the governor of California. This was a case about mental health. And basically, the case established, actually it's a fairly important federal legal landmark precedent. It provided a clear federal definition of what a minimally constitutionally adequate mental health system is in a prison. And it defined it as such. You have to have proper screening, timely access, appropriate levels of care, adequate medical records, proper administration of medication. This is not your preferred Blue Cross PPO. We're talking about the bare bones minimum, constitutional minimum. And they found that basically California lacked all of it. And they ordered California to create a mental health system, which is a process still not completed nearly, well, this was 1995. So coming up on 20 years, still not completed. One of the reasons the Supreme Court was fed up in Brown versus Plata. But the case really did two very important things that help understand why this is a broader kind of challenge to mass incarceration. For one thing, it actually documented how many mentally ill people were in the prison system. We now know that around a third of our prisoners suffer from a major mental illness. In many cases, it's probably what led them to prison. It also documented that while they're in prison, they absolutely get no treatment for this. Their conditions actually get worse. So to the extent that you think that holding people in prison is a way to, again, keep communities safe, when you begin to counter with the fact that you're cycling back into the community people who have been held in an institution pretty well designed to degenerate their mental health and receive no mental health treatment and had a mental illness to begin with, you begin to get a flavor for that something is profoundly wrong here. The other thing that really came out in this case is that these prisons had been designed without any intention of providing mental health treatment. And that's kind of shocking because, as you know, if you've studied the history of prisons at all, the idea that criminal psychology might be relevant to prisons and what we do with prisons has been part of the whole modern experience of punishment. And so this was really a repudiation of 200 years of penology, in effect saying we don't care about people's mental lives at all. They're just bodies, right? And you begin to see that we're taking a step here toward total dehumanization of the prisoner population. The second case was called Plata versus Schwarzenegger. It was originally Plata versus Davis, Governor Davis at the time. This case raised the same Eighth Amendment issue as Wilson. You have to provide adequate health care. But instead of focusing on mental health, it focused on physical health. And it resulted in a 2002 essentially negotiated agreement between the state of California and the prisoner plaintiffs, which called for a massive rebuilding of an entire prison hospital infrastructure, because there essentially wasn't one. California prisons had been designed without really any adequate hospital or routine medical facilities. Now, this quote comes from the great Judge Thelton Henderson, who has been the judge on that case from the beginning. But 3 years after that negotiated agreement, he took the case back and essentially found California in extreme contempt for not fulfilling its agreement, and he essentially ordered a receiver. And a receiver is just an extreme version of a special master. It's the equivalent of a bankruptcy receiver. Essentially, the judge was declaring California bankrupt when it came to managing its prison system. And this was a pretty staggering quote. He said, "It's an uncontested fact that an inmate in one of California's prisons needlessly dies every 6 to 7 days due to a constitutional deficiency." So just imagine what this means. We're not talking about somebody getting, end-stage liver cancer like, Joe Frazier and dying. We're talking about somebody who has asthma and would be alive and fine if he had his asthma medication with him. But because he's been moved around several times in a very overcrowded system, and because they make no effort to track your medical needs or to keep your medicines with you, he has an asthma attack, his asthma medicine isn't there, and he dies, right? That's a completely unnecessary death. It's a death that I think even John Yoo would call torture. That is, it approximates major organ failure. In fact, it is major organ failure, although only due to the fact that you've been denied a drugstore solution to your routine medical problem. And on this basis, he, as I said, ordered a receiver to try to push this case forward. I don't have time to give you all the details, but part of what these cases have done is just document the level of inhumanity practiced in our prisons. So these are all from the Plata side of the case. A prisoner repeatedly requested to see a doctor regarding acute abdominal and chest pains. The triage nurse canceled the medical appointment, thinking the prisoner was faking illness. When the prisoner requested transfer to another prison for treatment, his doctor refused the request without conducting an examination. A doctor did see the prisoner a few weeks later, but refused to examine him because the prisoner had a bad attitude, and the prisoner died 2 weeks later. Another case of a San Quentin prisoner with hypertension. This is a very telling case. Diabetes, these are all chronic illnesses which are rampant in our prisons today. He was prescribed 2 different medications. That actually exacerbated his renal failure. An optometrist noted that something was going on because of his retinal bleeding. He ordered an immediate evaluation, but as very typically happens in California, this never took place. It was a year later that he finally got his renal failure diagnosed, at which point he was referred to a nephrologist, that's a kidney specialist, on an urgent basis. He should have been seen within 14 days, but he never saw anybody, and he died. And this was a quote from one of the plaintiff's experts. "It was like watching the natural history of blood pressure turn into chronic renal failure, somewhat similar to the Tuskegee experiment." So you're getting a feeling, I think, for what California was doing. It was conducting medical operations that were not only scandalously negligent, but they essentially were the equivalent of, a massive human rights abuse, something that you would be tried in The Hague for if you were a European official, right? You'd end up as a war criminal. People like Governor Davis, Governor Schwarzenegger, etc. One other medical issue, medical records, right? Nothing is more important to modern medicine than medical records. If you were to be seen by a doctor who did not have your records in front of her, you should walk out of the room. I mean, it is less than not getting good treatment. It is a clear and present danger to your health. Why? Because you may be under medications that the remedies that she will prescribe for you will contraindicate. You may have various symptoms in the past that would have told her that your new symptoms indicate some very specific problem. In other words, medical treatment outside of an emergency situation without medical records is, gross malpractice. Well, in California, it's the routine way things are done. Medical records are just piled up in trailers. There's no effort at all to look at them. So if you ever get to see a doctor as a prisoner, there's no chance that they're going to have the medical records you need. Now, based on this long track record of abysmal medical failure combined with failure to implement these sweeping remedy orders from the courts, both Coleman and Plata came back together in 2009 to form a new court. It was a 3-judge court because the Prison Litigation Reform Act requires a court to have 3 judges on it if it's going to order a population reduction. Again, that's a way of trying to make it harder to happen. But despite the odds against it, this 3-judge court it produced a tremendous body of factual findings after a 14-day trial. I will send you a copy of this. You can find it online. Just email me, or and I can send you a PDF of it. But it is a primer in everything that's wrong with California prisons, how we got there. It is a sweeping condemnation of mass incarceration as a public policy. Notice this is from the opinion. Tough on crime politics have increased the population of California's prisons dramatically while making necessary reforms impossible. As a result, the state's prisons have become places of extreme peril to the safety of persons they house while contributing little to the safety of California residents. This is a sweeping condemnation of the whole enterprise of mass incarceration. And these images of overcrowding in California's prisons are part of what I think largely shaped the Supreme Court. And indeed, these are pictures that the Supreme Court appended to its decision. That's actually a rather remarkable thing. The Supreme Court very rarely, if ever, includes pictures with its opinions. Here they included 3 pictures, and I'm going to show you all of them. These are pictures of so-called bad beds. I'm sorry that one is way too blown up for these purposes. Let's look at this one's a little bit better. But you can see that this is something that's gone on in California prisons for more than a decade, although it arguably is improving today. These are spaces inside the prison, like a gym or a hallway. In order to house all the prisoners, they've put triple bunks in here. These are all, felony, according to California, some of the most dangerous people in the state. And yet, as you can see, they're not behind bars. They're mixed in together in a way that can't possibly be policed. As you can see, this is very much like the kind of scene John Howard was looking at when he went into the 18th century lazarettos, a swarm of people, some of them suffering from medical conditions. A lot of these, we know a third of these people are seriously mentally ill, right? So imagine that you're a schizophrenic and you haven't been medicated and you're surrounded by lots of other prisoners. It's a pretty scary, pretty freaky situation. Did I lose one of my slides? There it is. This was the third slide, and it may have been the one that most affected the Supreme Court. This relates to the mental health side of things. These are what are called dry cells. And what California does is, because now they can identify people as mentally ill, because Coleman forced them to, they can also identify people they think are at risk of committing suicide. But they can't find places to put these people. So what they do is they put them in these cages where they can't commit suicide. They're stripped naked and they're watched. But they can't really lie down, so they're crouching or standing. There's no toilet in here. That's why it's called a dry cell. So they have to urinate or defecate on themselves. And they're basically kept in these cages for weeks or months until they can be brought to an adequate a cell where they can be monitored. Now, this image profoundly disturbed the Supreme Court. This is Justice Breyer during the oral argument on Plata, on Brown, back in December of 2010. He actually asked California's lawyer to get out that picture from one of the briefs. And he said, now you've looked at them, I've looked at them, what is the answer to that? How can I or you, if you were in my position, what would you say? You've got a big human rights problem on your hands. And indeed, 6 months later or so, when Brown versus Plata came down, May 2011, the Supreme Court spoke in language that it hasn't used in a very long time to talk about prisons. It talked about dignity. A prison that deprives prisoners of basic sustenance, including adequate medical care, is incompatible with the concept of human dignity and has no place in a civilized society. Now, I want to just close by spending a few minutes trying to reflect with you on why this case could be a turning point for mass incarceration. I believe mass incarceration, as much as